Thanks everybody for coming, and for those that are dialing in on or zooming in, I guess, on the Zoom link. So so let me first kick off. So my name's Jay Knight. I'm the managing partner of the Nashville office for Barnes and Thornburg. I chair our securities and capital markets practice. I also chair the American Bar Association's Federal Regulation of Securities Committee. So we have interacted a lot with the SEC Commission and staff on rulemaking efforts. And prior to Barnes and Thornburg, I was at the SEC from 2007 to 2012 and was involved in Division of Corporation Finance during that time. So we are super pleased and grateful that Commissioner Uyeda, you had time to come here today. We really appreciate it. A little bit about your bio. So Commissioner Uyeda serves as a commissioner at the U.S. Securities Exchange Commission, bringing over 2 decades of experience in securities regulation and corporate governance. He was appointed to the SEC in 2022, and he's the first Asian American to serve as an SEC commissioner. Before his appointment, Commissioner Uyeda has held several key roles within the SEC, including serving as counsel to previous commissioners and as a senior attorney in the Division of Investment Management. In addition to his work at the SEC, Commissioner Uyeda has experience as a securities counsel in both public and private sectors, including working with the U.S. Senate Banking Committee, where he helped shape significant securities legislation. He is known for his thoughtful approach to regulation, emphasizing the importance of fostering capital formation while ensuring investor protection. He has been an advocate for transparent and balanced regulatory frameworks, especially in areas such as shareholder engagement, ESG disclosures, and the evolving role of technology in financial markets. Please join me in welcoming SEC Commissioner Mark Uyeda. So we have time initially for, well, I guess one thing I would say is, so I'm really hoping this would be a dynamic discussion, and we don't have a fireside chat. I thought about printing a piece of paper off, and here's our fireside. But we will have time at the end for audience Q&A, or for those on the Zoom for Q&A. Feel free, if there is a question that you have, let us know, and we'll try to get a microphone to you to answer it. But there will be a Q&A at the end. And so if there's any introductory remarks you'd like to make, or we can just dive right in.
Sure. Well, thank you for having me here, Jay. It's terrific. I know we had a great conversation earlier this year at one of the, I guess you can say, the regular securities law conferences. But one thing that we talked about was, hey, can you come down to Nashville? And I said, well, absolutely. I have just driven through once before on I-40 when I was driving cross country, so that doesn't really count visiting Nashville. But when I was on Senate Banking, had the privilege of serving with Senator Bill Hagerty, who in fact I was just with. Senator Hagerty was leading a bipartisan delegation of senators over to Korea, where they're talking about the importance of our relation to the U.S., Korea, and Japan. But Senator Hagerty, I know, Vanderbilt grad, as was my very first SEC, or Vanderbilt law graduate, as was my very first boss at the SEC. That was Commissioner Paul Atkins. So he went to Vanderbilt Law School. So it's a real privilege for me to be here. And I should also add, one of my staff members is from Nashville, and he would never let it down if I did not visit Nashville at some point during my tenure as commissioner. So glad to be here. I am one of the 5 SEC commissioners. And so, as those of you probably heard, my views today will reflect my views as an individual commissioner and not necessarily the views of the full commission or my fellow commissioners.
Sure. Thank you. Yeah, and welcome to Nashville. Obviously, we're not serving hot chicken for lunch, but I understand you all had some hot chicken, or at least I know Charles did.
We did.
Yes. So we'll start off today with just a little bit of broad topics, such as you've been at the SEC as a commissioner for a number of years now, and then before that is in leadership roles. And so maybe I'm curious if you have encountered any successes and challenges in just at your time as a commissioner or on the staff that kind of are memorable for you, successes and challenges that you may want to expand upon.
Yeah, I think the one aspect of my long tenure at the agency, although I've had numerous assignments, been detailed out to other executive branch agencies as well as the Senate banking, has been recognition that regulation, you got to think about over the long haul. And that can be really tough, I think, when you're on the commission, because we're just appointed for 5-year terms. And if you are serving as chairman, whether you're Chairman Clayton, Chairman Gensler, Chair Mary Jo White, you are further somewhat boxed in by the presidential, whoever is got the current administration, because they tend to change if there is a new president and a new administration. So you tend to think about what can you do, but in an odd sense, I've been thinking about a lot of things since almost 18 years in terms of how we think about our corporate disclosure regime, how we think about shareholder proposals. Occasionally, I have talked to some relatively new folks over the SEC who've been practicing a lot less time, and they'll say, well, there's this issue on shareholder proposals. And it's like, yeah, we've been having this issue going back to the 90s and probably even before that, because that's just when I started. So I tend to take a long haul. In terms of biggest successes, it's hard to pin down one, but I was sent over to the Treasury Department on a detail in 2017, 2018. And the reason why I think about that as great successes is I was one of the authors behind a series of reports that the administration put out at the time, the Trump administration, of how we should think about regulating banking, capital markets, asset management, insurance, and fintech. So a series of 4 reports. And that was based on an executive order which set forth 7 key principles. And some of them, I think most of them, or people would not find them disagreeable, like regulations ought to be effective, efficient, and appropriately tailored. That regulation should not disfavor American companies competing on a global stage. Regulations should promote capital formation and wealth creation by investors. So that was, with that kind of very, very broad goals, trying to then assess and think about what recommendations should be taken with respect to how we regulate, but also taking a bit of a stock take as to here's what the regulatory world looks today. At the SEC, is when you're in Corp Fin, you're looking at the 10Ks, you're looking at the proxy statements. That's your world, you're offering, and all of a sudden now I'm having to think much broader. Well, where does the capital formation part interact with the banking world and the insurance world, which is something that we oftentimes don't think at the federal level because it's largely regulated by the states. And where do asset managers come in? And how does this overall rubric of financial stability, and I would say more than anything else, that helped prep me for my current role as commissioner? Because now I have to think of the big picture. I can't be, while the details are super important, it's beyond just simply, well, how do we think that 1488, this exclusion ought to work?
Yeah.
You have to think about where it fits in with the bigger picture.
Right. Yeah, that's the long-term perspective of it really does make an impact, because a lot of these rules that we're looking at right now were, adopted many, many years ago. And I think you all have pointed that out in some of those rulemakings, right? So, the topic today we're talking about is shareholder engagement, and I represent a number of public companies, and a lot of public companies are owned by some very large institutional investors, and they're concentrated in many respects. I'm curious of your viewpoint on institutional ownerships, and do you think like some of the institutional owners have an outsized influence in corporate governance in particular? And what role should the SEC have in regulating that space anyway?
Things have really changed in the last couple of decades in 2 particular trends. One is the rise of passive investment vehicles, index-based. And then the second is on the corporate governance side, majority voting for directors versus plurality. Now why does this differ? Because we think about, well, who controls the corporation, who can exercise, in essence, influence. It's not just legal control. We think of effective control. And this gets into who's a 13D filer versus a 13G filer, for instance. What does it mean for the disclosures if you have control persons? BlackRock, Vanguard, and State Street all get together and say, we want to form the following changes, whether it's on their own or whether through one of these particular other groups. All of a sudden we'd say, well, wait a minute, just because you are not a traditional someone who wants to take over the company or otherwise, you look at our rules, which haven't changed. What is control? The ability to influence the management or policies of a company. That hasn't really changed, and is that effectively what they're doing? So the world has morphed. Our rules, I think, conceptually have been the same. And I think this is something that has gotten a lot more come into focus recently. Given that you now have this authority as an asset manager, if you look at especially the way shareholder voting works, you've got probably the top 10 or 12 asset managers control a pretty good chunk of your shareholder base. Another third of your shareholder base is likely to be highly influenced by one of the proxy advisory firms. So between those two groups, you can potentially influence a lot within a company. So how should our rules think about that? This is something where, when I look at the asset managers, I think they've been more cognizant that if we want to stay a 13G filer, we can't be doing things that might be exercising control or influencing control. And if you, and it's, at least this is my view, you can't simply say, look, I'm going to vote against you if you don't follow the following 10 things that we have in our stewardship code, which, I understand if you go in and say, look, I will vote against your lead independent director, I will vote against your noms committee chair, or other independent directors if you don't do the following things. But you effectively accomplish the same thing if you say, well, just as a general policy, where, if your company doesn't tick the following things, we're going to vote against certain members of your board. I think there's more sensitivity about that. And I think that's good. Because like I said, the rules haven't changed. It can't be like our off-channel communications enforcement cases with the text. We're saying, well, the rules been the same. Just because the technology has changed doesn't mean that you now no longer have to comply with this rule.
Yeah. Do you think that there are gaps that are in the rules to help address some of those situations? Because you're absolutely right. Like it is how the reality works is that a lot of companies will review those policies and guidelines and drive behavior to, make sure that their directors don't get a negative vote, which, and I can see both sides of it. And we have a diverse mix of people on the panels today because there's different viewpoints on it. But I'm just wondering if you see there's any gaps in the rules right now that kind of encourage that or discourage. And I know that there's been rules on proxy advisory firms and transparency for voting and those things, but I'm just kind of curious your thoughts.
Well, I think that's what you just identified. Proxy advisory firms is a big question mark. There's currently ongoing challenges to some of the rules that the commission has adopted, including, I think, a very fundamental question, which is, are proxy advisors subject to the Section 14? When they provide a recommendation on a vote, does that constitute solicitation? And that's a question for the courts, and that'll work its way through. But how should we think about, given the outsized influence of that, are they investment advisors? Or, one of the major ones is, others might take a differing view. We talked about this in our 2010, I think, proxy plumbing concept release, but we haven't done much since then. That was 14 years ago. So yeah, that's why when I think about the long term, and I feel very fortunate that I've had a history, worked on the 2010 concept release when I was on the staff. It's always amusing when I will have someone come to me and says, well, there was this release in 2010 where we addressed it. I said, yeah, I worked on that.
Yeah. Yeah, no, you're exactly right. Speaking about proxy voting and you mentioned shareholder proposals earlier. I did a couple stints when I was on the staff on the shareholder proposals task force, and I think that some people on the outside don't appreciate the volume of work that goes behind, even when the company gets one-page issue, like we concur or we don't agree. There's a lot of analysis behind it and a lot of hours of staff time to make those decisions and trying to be consistent. And I really believe that. But that said, like the staff is really the arbiter of a process. And I remember doing some rulemaking on staff in the securitization area, and we were like, the deputy director at the time was like, we do not want a 14A8 process in asset-backed securities. You know, it's just like it's a life of its own. But I'm just kind of curious your viewpoint on shareholder proposals. Do you think that there are adjustments that we need that related to that, or you think it's calibrated the right way? Kind of, you know, how do you think where's your viewpoint on just where things stand right now with 14A8 shareholder proposals?
Well, first, you're absolutely right to point out how much work our staff puts into evaluating each 14A8 no action request. It is a lot. I've seen the backup that goes into that, and it's something that nobody on the outside sees. And you know, I understand it's a bit of a black box. It goes in, you send in your request. Oftentimes, you're not quite sure which is the right argument. So typically the company will have every possible argument in the hopes the staff will latch on onto one. Procedurally, though, I think the 14A8 process is it's in this weird spot in the sense that the staff, as you point out, makes a decision and acts as an arbiter. But that is one of the few things that is not subject to commission review. So if you're not happy with what the staff does, you cannot say, well, I'd like to have this called up for a vote by the commission. Now, why is that important? Well, if the commission acts, then, and someone still feels aggrieved, whether it's the shareholder proponent or the company, they can then take it out for judicial review, and the courts can weigh in on that. But right now, the current posture is if the staff renders its decision, since the commission has no ability to review that, there never is a commission decision, and you cannot appeal that decision of the staff to take it, for instance, to court. And I think we saw that with some of what you saw this past year. There were some, at least one issuer, maybe more, who went directly to federal district court on that. I think the staff provides an incredible service, but this is one area where perhaps it ought to be slightly reformed so that there is some method of appeal and ultimately judicial oversight, because I think that's important. And I think that's a theme that we saw from the Supreme Court in a series of cases thinking about the executive branch and what sort of judicial oversight should there be over actions of administrative agencies and the executive branch. And the answer is, this is a decision that could have profound impacts, but it is totally not subject to judicial review. I think in the long term, that is probably not the right position to take.
Are you all, is the commission consulted on, I mean, some proposals are extremely high profile, some situations are high profile. Are you all consulted even if the staff doesn't follow? I'm just kind of curious how the back office works with that.
I think it really depends on the leadership and the approach they take. Ultimately, the chairman, whoever sits in the office of the chair, has full authority over all the staff. My joke is we got 4,900 employees. They all report to the chairman except for the 5 who report up to me. And the chair decides what information they want to share with the other commissioners. When I was on the staff, or when I was counsel to Commissioner Pivovar, the chair's office and Keith Higgins was the director, came around and said, well, we're going to reverse this one position on that we've taken a previous no action letter, and we want to explain why. So it does occur sometimes, but it really just depends on what the chair and the then director decides of Corp Fin they're going to share with the commissioners.
Mhm.
I've always, when I give advice to our division directors, well, one of the things that commissioners don't appreciate is when the first thing they hear about something is when the press or reporter calls up about it.
Mhm.
It's, and I think it's no different than most other, all of you are in businesses. If something bad is going to happen to the company where maybe you're an executive or you're sitting on director, you should hear it internally before reporters start calling about it, or you've seen it in the news. So I think that's just a matter of internal processes, but it is highly dependent on who's in current leadership.
Got it. Yeah. ESG is a very popular topic. It's been, a very popular topic for a number of years. The commission has issued climate change disclosure rules, and those are, without getting in the court process, but curious your thoughts. What is your thinking around the ESG landscape right now? You have some companies that are leaning into it, some are leaning away, some are, depending on what business they're in and what their customers are saying and what stockholder pressure they're getting. I'm just curious from your vantage point because you probably see a lot of different viewpoints in your position. Curious what yours would be.
Yeah. Well, one of my observations is after hearing about ESG from a lot of different viewpoints is ESG tends to be in the eye of the beholder. What exactly is ESG? And that's something that I think if you look at some of the comment letters that were submitted to the SEC in both connection with our fund names rule, as well as our fund names rule proposal, as well as our ESG disclosure rule for investment advisors and funds, what exactly is it? Now, from my perspective, companies have been having to deal with ESG throughout the entire history of corporations. As a director, you have fiduciary duties to act in the best interest of the corporation and by extension, the shareholders. And that means having to balance and make trade-offs. And you've got employees you have to worry about. There are customers you have to worry about. There's compliance obligations that you need to worry about. There are all sorts of other things and that's what between management and the board trying to decide how you allocate resources on that. With respect to our disclosure regime, my longstanding view has been it requires disclosure of material facts and risks to your investors. And if that involves an E, S, or G factor, that already needs to be disclosed, even if it's not specifically called for in a line item, because it's going to be covered somewhere in the description of business, material risks, your MD&A, elsewhere. So if it's going to materially affect the financial performance of the company. So once we get into mandated rulemaking, then the question I have is, well, are we now in essence demanding non-material ESG disclosure? Because if it is, if you're having a big labor relations issue that's going to affect your ability to revenues, because workforce is going to go on strike or other things like that, those or your costs are going to significantly increase. Again, those are things you don't need a specific human capital management disclosure requirement. If it's going to materially affect financial statements, it needs to be in there. And if you have other issues on human capital that are not material, you have to question, well, why do we want that in there? What exactly is it that we're seeking? And I think if you look at the share repurchase rule that we did that was subsequently vacated by the court said, you didn't explain what exactly we were trying to address. Again, we constantly get new staff, new turnover, which I think is healthy for the agency. But there have been so many times where I've heard, well, we need this because it's just the right thing to do. I said, well, that's we're a government agency. We can't just say it's the right thing to do. We need to articulate why it's the right thing to do. Why is this important in making an investment decision, not just, well, it's your opinion uh, uh, that we should do this.
Mhm. Do you think that the topic of materiality is quite interesting because do you feel like what material is defined as has evolved over time? So think of your, from when you started and now where it is today, like, have you seen an evolution of what material means? Or like, is this just kind of a cyclical thing and we're kind of in one spot?
I think there are different views on materiality. I get back to financial materiality, and I go back to TSC Industries versus Northway and basically Levinson, and they make very clear it's an objective standard. It's not a subjective, which again, sometimes that gets lost in the discussion because someone will say, "Well, we talked to a big couple of state pension plans, and they want this information. Ergo, it must be material." Well, no, I don't think that's just because they want it or because maybe a big asset manager wants it. And also exactly what is motivating them. My experience has been, if you ask any financial professional or institutional investor, and you say, would you like more information at zero cost? The answer would be, oh yeah, I'll take that. I'd always rather have more information than less. But that doesn't necessarily mean that they'll use it or need it. And that's when we do our economic analysis, we need to be factoring in it. So it just can't be simply someone asks for it or a handful or even a couple scores of folks want it.
Mhm.
Again, what is the financial impact of that?
Yeah, yeah. So you mentioned 13Ds earlier. One of the panel, it will be talking about activism and activist situations. Curious your thoughts around just activism and, their impact on corporate governance. Should there be more regulatory oversight in the activism space? Do you think it's calibrated correctly? And understanding we have the backdrop of recent 13D, 13G amendments and you mentioned control earlier, which I found quite interesting, your comments there. So just kind of curious, like activist investing in the landscape we're in, kind of where do you think we are on regulatory oversight to that?
What I look as my guiding principles, we need to have an efficient, fair and efficient market, and activists are an important part of that. I mean, we need all types of investors in the market. That's what makes it work. People are making judgments about the valuation. Some think that the price is too high, some think it's too low. And then when they put actual funds behind buy, sell, or hold decisions, that's how we get price discovery. And to me, that's one of the most important things to safeguard about our markets. One of the concerns that I've had is once you get more and more into passive index funds, are stock prices being more influenced by fund flows? So if people are putting money into their 401ks or they start taking them out, what have you, affecting stock price? Because the indexes providers are not making fundamental decisions on valuation. And so those who follow them are simply just trying to match whatever index there is. So going back to your question, at the SEC, we should be, we're not merit-based. Our job is to provide a market in which investors can make those decisions. And that is really where all those decisions should be made. Shouldn't be trying to put our thumb on the scale one way or the other. We should be making sure that there's appropriate transparency. But we also, or at least in my view, that doesn't mean we need full and complete transparency, because the very incentive for a market participant to try and gain value is by coming up with an idea or doing analysis. All that takes time, money, and effort. So it's not the government's role to say, well, thank you for all your effort, you now need to make that public to everyone. So in essence, they can free ride off your intellectual efforts. Um, if you do that too far in the direction of transparency, for instance, ultimately that'll discourage people from doing that analysis to begin with. And once you have people who stop doing fundamental investment research and decisions, then all of a sudden the market becomes a lot less efficient, doesn't do its job as allocating risk, it doesn't think about our risk return, and then the capital markets don't work the way they ought to be, or at least optimally ought to be.
So are you saying like, if activist investor A is required to share their model behind that may, like, I just want to make sure I understand. Are you coming at it from that there may be a little bit more to transparency on the disclosure around the investment decision and the reasons for that? Or are you saying that the company is providing maybe a little bit more transparency? And I just want to make sure I understand which direction.
On the investor side.
Yeah.
In fact, we just had something that we considered either last week or the week before on mutual fund disclosures. And they want more frequent disclosures. Well, if you're an active manager in the mutual fund, especially if you're thinking on long-term buy and hold, again, that takes effort. You have to hire analysts, you have to hire portfolio managers to think about that. It's not simply track an index from MIXI or S&P or whomever. If you can have to provide that free to the public, well, why should I pay a management fee? I could just go into a separately managed account. And already there are a fair number of broker dealers who you could say follow particular portfolio managers. They'll do this actually on the 13Fs. Find your favorite, I think Warren Buffett files a 13F. You want to follow him. Now everything's in structured data. You can fractional shares, not an issue anymore. I mean, this is how the technology advanced, which I would say is a good thing because it allows a lot more accessibility to retail investors, but it also says, well, I can just follow somebody, set it up automatically to track their moves that are disclosed to the SEC. I think that changes, again, the nature of, well, why should I spend all this effort to make investment decisions that I might if I was a mutual fund active manager, if people can do it for free, follow me for free. Why would they pay for my service? In which case, less likely that you're gonna have people providing that service to begin, or making those, having a business model where running a fund makes business sense.
Yeah. Okay. That's helpful clarity. You mentioned technology. One of the things that, us as a law firm, businesses, community, just technology overlay. I think you were talking about blockchain last week or the week before in Korea. AI, like, how do you see, when I think of AI right now, I'm thinking of like internally how you use AI, but also externally how you use AI. I'm just curious how you see maybe the internal use of AI within the division or within the SEC, just like analyzing filings, or if that's already being done right now. And then from an external perspective, like, I was just thinking, I mean, you could create some hypothetical where, what if you have a chat GPT that, you say, can you, do my trading activity for me? And then it learns some inside information and it goes out and buys some stock on inside, like could chat GPT be insider trading? So, I mean, you could take this anywhere, but I'm just kind of curious your viewpoint is, because it's such a developing area and it's quite interesting.
Yeah, I think it's one where you look, like with any technology, tremendous potential benefits. Also, there are unknown risks, and we should not be, anti-innovation. You could have AI, for instance, at least in my area, the local traffic, the local county has cameras to monitor traffic. Could AI monitor how many cars are going in a particular retail outlet or not, and read that, and then rather than having a human individual count the number of cars, automatically do that, and you can detect trends. In fact, that's how we detect, well, not through traffic cameras, but one innovative way we had an enforcement action where we discovered there was fraud because it involved the use of satellite pictures of certain areas where they said the activity was going and actually showed there was no such activity occurring. So technology is always changing, and you can have models to do that. We are demanding more data than ever. Whether it's companies, whether it is now what's called the consolidated audit trail, whether it's the filings we made by investment advisors, filings on something called Form PF by the private funds, the focus reports from broker dealers. How is a human going to really sit down and analyze that? I mean, you can do some things with traditional spreadsheets, so to speak, but there's a lot more out there. So yes, can AI be used? I mean, we already are using, I would say, relatively straightforward. You can look at values and you can find anomalies in the data. In fact, we were doing that with 13F filings for a long time because if you go back to how it was forget when we fixed this, I want to say up to 5 years ago, you had to put in the dollar value, but you had to lop off the last 3 digits. So if it was held $1 million position, you would have to put down 1,000. Now the reason was because the original filings were in ASCII, and so there was a limit of 144 characters across. But once we moved to structured data, we never really caught the instruction up. And so some people, if you had 1 million shares, they would put in, or $1 million, they would put in 1 million, which is 1 billion. And so we had to create some filters inside to say, well, this looks like an anomaly. It probably should have been 1 million, not 1 billion, to flag those sorts of things. And then when we ran our own internal analysis of that, we would have to apply this sort of corrective filter because, in some cases, it turned out 1 billion was larger than the entire market cap of the holding. So it couldn't possibly make sense. We're collecting more information than ever. And AI, I look at it as another incremental tool that we can use at some point. But again, we got to be cognizant of the risks they have for false positives and false negatives. And then, as you point out, there are concerns about generative AI and what that means.
Is there within the SEC just like an AI committee, or just kind of like even with Edgar? I mean, I think everybody that does securities laws, like you salivate and you start thinking about Edgar. Maybe not salivate, but you get really excited. You get excited to think about, wow, all of the data that's in Edgar and pulling stuff out. And, I'm just kind of curious within the SEC, or is there a concerted effort to use the data that's in Edgar with like layering an AI on it? I mean, I'm sure like IntelliGeyes and a lot of the third-party vendors are kind of thinking about this, but, you can obviously see it. There's not a long, thread to see when AI can get on top of Edgar and how that could be utilized.
Well, the great thing with Edgar is it's available to the public. And so this is one where, I think that there are potentially going to be some third parties who look at all this data and come up with ideas and tools and can experiment with that. And so you joke about salivating over Edgar. I feel like I grew up with Edgar because I started practicing in 1995. And that was the first, I think about the time Edgar became mandatory. It was no longer an option. And so as a first-year associate, I remember a fourth year throwing some booklet at me on Edgar and says, I don't know what's going on. Your job to figure out how this works. And so I feel like I've grown up professionally with Edgar, including going over and telling every junior associate who then worked for me, you need to look at the header tags. It's like, well, it says on the cover sheet, it's this. Like, no. Whatever it says on the cover sheet doesn't matter.
Yeah.
It matters on what is in that Edgar header tag. And if you change what's on the cover sheet and you fail to change what's in the tag, header tag, you're gonna have a problem.
Mhm.
And so I'm glad that we finally fixed that.
Yeah.
But again, it was something funny when I got called in for a briefing. I was with Commissioner Pugh about 10 years ago, and they started explaining to me what an Edgar header tag was. It's like, all right, I got this. I was there with some councils from other commissioners. I don't think they had the same Edgar filing experience because again, the SEC, we draw from a lot of different types of or lawyers skilled in securities, but some are on the enforcement side, and so they're not stressing out at 2 a.m. trying to make sure that everything's ready for your filing.
Right.
But yeah, I found that kind of funny.
Well, even just like filing fee table, like that was for the long time just a manual process, and and now it's digitized and all that stuff. So, well, we're kind of toward the end of the fiscal year for the SEC. So September 30th, I think, is the end of the fiscal year. I'm just kind of, between now and election or short after, what do you see as like, I imagine there's a lot of activity going on. Both one to get correct me if I'm wrong, but just to get the numbers, kind of good comparison against the prior year and election, who knows what's going to happen there. Curious, like what the activity looks like over the next few months and how, we should be prepared or be thinking about things.
Well, you're right about the numbers, and the specific numbers we're looking at are the enforcement numbers, and those tend to get measured over the fiscal year. And so in my whole at this point 18 years at the SEC, it's never changed. The SEC has always historically tried to, if you have matters that are close to being wrapped up, well, let's go ahead and get them wrapped up by the end of September. We are entering the last year of the administration, and so I think there are going to be a lot of attempts to try and tie things up. So you don't know, or at least on the rulemaking side, what can be tied up and finalized. Chairman Clayton did that. Chairman White. No reason to think Chair Gensler would be act in a different manner, that there are things he's going to want to try to get done because of the uncertainty.
Yeah. Do you think that the Supreme Court's decision related to Chevron and just kind of the administrative rulemaking impacts that it's going to have, do you think that is having an impact in the rulemaking pipeline right now or recently, or how do you see those impacts, or do you think like that should have an impact in it, and you haven't seen it yet?
Well, it's something that we have. Any good rulemaking effort always has to consider what is our statutory authority, and why do we think we can do this? And this is a question that has come up. Likely will come up in challenges to our rules. Our disclosure, for instance, on the public company side, says we can require disclosure. We find it's for the protection of investors and in the public interest. Well, what exactly does that mean? Are there any practical limits on that? And there are different viewpoints on that. My personal view is that is imposed a materiality. So would this be important? And I spoke earlier, I think it's principally financial materiality, but I recognize that you can also have qualitative materiality. How do we justify, we're going to require the company name, even though you might say that's not a financial material fact. That's pretty important to require on the prospectus, the company name and the stock ticker symbol. But again, what does that mean? Does it mean in essence that as long as we say it's in the public interest and protection of investors, it's anything? We can put, as I've joked, there have been studies of the people who become presidents, and there is a large number who have been left-handed. So, and there's sort of this question, well, does that mean anything? Well, does that mean we as the SEC, okay, well, if we think there's merit, we should disclose which members of the executive management team are left-handed and which ones are right-handed. Would it justify that? Is that what our statutory authority allows?
Does it?
That is a good question, which I will not hazard to answer at this particular session.
Whatever it's in front. Well, I do want to leave, and I have some more questions, but I want to be able to have time for Q&A as well. So let me open it up. Does any, yeah.
So you spoke about NACD, the BD40 board of directors, and also the chair-elect for NACD Nashville. So you all spoke about materiality a little earlier. Could you comment on materiality as it relates to cyber events? And we talked about this before you started. The rule says report 4 days after the determination of materiality. What we're seeing in all of the filings is people are reporting and saying it's not material. Is there a learning going on? Is there an expectation that things may change? Or could you just provide a little color and insight into the trends that you're seeing?
When we adopt a rule, we engage in something called notice and comment rulemaking, which means we publish what we intend to do. We get public comment, and then we make a final action. But my experience has been you never tease out all the potential practical implications of when you do the rule, especially if the final rule deviates from what was in the proposed rule text. And so we are in a bit of with any rule, I would I call it kind of the shakedown phase. You're trying, it's like building a new house and you realize, okay, this doesn't quite work the way I thought, or there's this problem that I hadn't thought about before. And so now we're getting some practical experience with this. So what we've seen already is some guidance that has come out from our Division of Corporation Finance to try and, all right, if we're not getting the anticipated responses, and that's why you saw some guidance that said, all right, maybe this shouldn't be an item 1.05 filing, but it should be an 8.01 filing under 8K. And this is where I think it's really important for the division and the SEC staff to hear feedback. And ultimately, I think all of our staff wants to have something that's workable, and people understand what's required. We also think about it from an investor's perspective. This is intended to help investors, and so it potentially does make a difference when you see on Edgar, well, this is a 105 filing versus an 801. Yeah, I would expect, like with any rule, we'll see what happens, and then to the extent that the staff determines to be helpful to provide guidance, those are the types of things which I think can really, or we can assist as the regulator, all of those who are subject to the rule understand what their obligations are.
Mark, first of all, thank you for the delightful discussion. My name is Rod Cotton. I'm on board of Castle Biosciences, and you mentioned shareholder activism, and I'm just wondering how you think about this in terms of, when does it go too far, right? And who has outside influence in terms of individual personalities, like a Carl Icahn, for example, or asset managers that you referred to earlier?
Well, when it goes too far is when you have market manipulation and other types of fraud in connection with those activist attempts, but short of that, I mean, they're an investor. Investors have, there are all sorts of investors out there, and this is something that sometimes you see, and when we talk about going back to, for instance, proxy voting, there are hedge funds out there that hold a position for the day. And if that day happens to be a record day, they're going to end up with that vote, but they may not have a position later on. And for instance, for us, on the investment management side, I say, well, you've got a fiduciary duty to vote the shares. A hedge fund, it might be very different than a long-term buy and hold active manager, because a hedge fund's like, I'm just looking at price discrepancies and I'm in and out. And what the company does in terms of governance, it just doesn't matter for their strategy, whereas that may very much matter for a different type of investor.
Thank you.
Hi, I'm Dave Hooper. I'm co-chair of our securities capital markets practice group here with Jay at Barnes and Thornburg. I have a follow-up question on the materiality issue that you just brought up in the context of SEC rulemaking. You know, we're all aware of some of the high profile rulemakings, and, you know, there's various assertions that particular issues or topics of the rulemaking, particularly the climate change disclosure rules, are important to shareholders, are material to shareholders. From your perspective, how does the commission, and particularly your colleagues, the 5 commissioners, determine a matter is material? Because at times it appears there may be assertions that an issue is material or important without more to particularly back it up, and certain commissions think that issues are material that others don't. So how does the commission determine that a matter or a topic is material or important to shareholders to back up the rulemaking?
Well, I can't speak for the other commissioners. Ultimately, there are 5 of us. We vote on it. I have my own process as to how I think it is material, and a lot of it is, well, show me how this affects. This would affect the stock price and enterprise valuation. Those are at least the 2 things that come front and foremost to my mind. And there are other things that you might think of qualitative material depending on what particular disclosure is looking. But that's what I do. Like I said, I can't speak for how the other commissioners reach their decisions. When I dissented from some of our rulemakings, I try to articulate the reasons for why I don't think that's the right approach. Sometimes, there might be elements of it which make sense, but other parts of it seem way too prescriptive. For instance, I had a fairly extensive dissent on our climate risk disclosure final rule.
Hi, I'm Hamilton. I'm a professor at Tulane Law School. I have a question about going back to what you were talking about with line item rulemaking versus materiality. So you made the point, which I think is probably true, that if a company's having major labor unrest or, that almost certainly that's going to be called for disclosure through a general MD&A section or through a risk factor section. And now, relatively recently, there's specifically a line item, human capital management. So, you could go at extremes. You could say, why have any line items? We could just say, disclose material facts, we're done. Or you could say line by line by line by line by line. So my question to you is, how do you think about when something is appropriate for a line item disclosure versus leaving it assuming it's material, when it's appropriate for a line item disclosure versus leaving it to in the risk factors, in the MD&A and so forth?
Yeah, so some of it can be just a matter of organizational. Like I wasn't there when we did the human capital management rule, but it did replace prior disclosure where we basically said, have the number of employees. And I think the commission appropriately recognizes, well, employees, what exactly is that? We're in a world where you can have contract labor, you can have certain types of services that maybe previously were provided in-house by outside vendors. There are, business has to decide how it wants to do those functions. So sometimes when we do have those specific types of disclosures, at least one way I look at it is to make it easier for a reader of that disclosure document to be able to find information, especially when I might want to compare one company to others in the industry group. You at least have a general way, because some types of disclosures, it may fit in a number of places. It could go in the risk factors, it could go in MD&A, it could go elsewhere. So sometimes helping that does reduce the cost of finding that information, especially as they get longer and longer to try and, I'm not the only person who's gone through an aggro filing. It's like, all right, I got to hit Control F to figure out where this term is, and you hope you get the right term that they use to figure out where that disclosure is in the document.
Mike Levin, I'm on a panel later on the investor side of things. I have a question related to how constituents interact with the SEC. So you mentioned earlier, we talked a little bit about the shareholder proposal process, no action letters and so forth. And, you know, my experience with this is quite limited. I realize there's a lot of no action letters that happen in all sorts of ways. But I'm thinking, you know, more topically about the 14A8, I think it is, world. And at one point you said something about how, yeah, I realized that there's a very brief statement of the staff position on one or another very specific, call it proposal. And I suppose there's sort of two questions here. The first is, you did mention there's a huge amount of work, proposal by proposal, that goes into this. And sometimes that gets lost. And, you know, if you're just one of the proposers, and particularly when no action relief is granted, and there's this one sentence line that says, "We concur," that gets pretty maddening. And I think I'm kind of curious about the reasoning why, and maybe it's just workload, or maybe there's other reasons why the opinion is, or the relief in particular, is kind of terse. But then I have a second kind of question about how proponents can learn from this. So let me stop for a second and let you kind of comment about what I just asked.
Well, I don't have an explanation as to why it is a terse. I know that has been the practice for a long time. On 14A proposals in general, I think this is an area where our staff does an excellent job of engaging in outreach. I know this is a topic that's often on conference circuits. On the conference circuit, I also know that they have a regular meetings with stakeholders where they kind of go over, this is what they saw. And they try to have representatives from both investors and activists and companies on that. And because there is a proxy season, I think it's a very valuable effort. And the reason why I say I think we do a great job is we don't do the same thing for, hey, let's talk about how MD&A went this past 10K season.
Right.
And talk with shareholders, hey, did you like what we're seeing, or things like that. So on that, there is a bit more of a, I would say, regular cadence in terms of interaction with stakeholders in that process. And then, of course, when somebody is not happy, they then call either some of the commissioners, my office,
Congressman,
other offices. Yeah. So we hear about that.
Right. Well, so that was, I think you started to answer the second thing I was going to pick up on, which is, should there really isn't, but should there be improved ways for like a proponent to ask questions and learn from this, and to say, okay, this one was deemed to be, you know, a favorite is ordinary business, or I can't remember, micromanagement, one of these exceptions. Is there a way to, or should there be a way for proponents to kind of interact and learn from this? Like yeah, I mean, is there a way to kind of, for us to learn from
Yeah,
this?
we have, so Office of Chief Counsel in our Division of Corporation Finance is responsible for running the shareholder proposal task force every year, and coordinating the responses. And so that's the first place I would start, if you know, to have that conversation. Hey, I want to understand exactly, or understand, and you know, like I said, they share things on the conference circuit, but I recognize not everyone goes to those conferences, and so reach out to them if you haven't heard them in those forums.
All right, I'll do that.
Commissioner Uyeda, thanks. I know I'm standing in the way of lunch. So Josh White at Vanderbilt, I'll be moderating the panel after lunch. I just, you know, I'm a former SEC economist, and the role of economic analysis sort of grew while I was there. Some of that was from, proxy access being overturned, and you mentioned share repurchases more recently. I guess one thing I'm curious about is sort of your perspective on the role of retrospective analysis. When we were economists, staff resources are finite. We're often trying to assess the costs and benefits of rules that had not been implemented already. And as Ed mentioned, sometimes you learn as you go with things like cyber. So I just was curious on your thought of, should we work that into rulemaking that we're going to conduct a retrospective analysis, or does that sort of post-implementation review, does it need flexibility? I've seen them come out of things like Dodd-Frank, but rarely worked into a new rulemaking. So I was just curious on your thoughts on that.
Yeah, I think we should. I think that's what responsible regulators do. The way I divide the world, I have this 2x2 matrix where a rule is either effective or not effective, and it's either costly or not costly. And in my world, you want rules to be effective and not costly. We have a lot of rules that are probably not effective, but also not costly. So people just are like, okay, well, we'll deal with it. But the worst ones are the ones that are not effective, but costly. And those are the ones where I think it's really critical. We say, all right, this doesn't make sense. At the end of the day, investors are paying for compliance with a rule that does nothing to their benefit, or maybe even might have, it's not even providing benefits. I've probably one of the few folks at the SEC kind of still talks about our conflict minerals rule. And when I look at some of the rule hasn't really helped the situation in the central part of Africa. Yet we're still imposing some burden on companies on this. And it's, well, should we take a look back and say, what were the intentions? Is this doing? Should this really be done? Especially when, again, the world has moved on. We're now in a time where copper and cobalt are very important for production of electric vehicles, but they're not covered by the conflicts minerals rules. But so it doesn't help to say, we didn't. We're focusing on tin, tungsten, tantalum, and gold, and now a lot of the concerns with our armed groups and forced labor has just moved over to as it's euphemistically called artisanal mining of copper and cobalt. So, hey, should we take a look back and maybe we should think about, what can we do here?
Thank you.
Okay, well, we're at time, and I just wanted to say thank you again for making the trip here. I think it's been really informative for those in the audience. Appreciate those that have zoomed in and watched this as well. So anyway, just want to say thank you. Appreciate it.